Good morning, everyone. Let's get the slideshow started. So I'm going to be talking today about what we identify or call intentionalism in estate planning. And what we're really talking about when we say that is how is it that you can actually successfully achieve your legacy? What does that entail? The discussion points that I'll be focusing on today, first and foremost, what does intentionalism in estate planning actually mean? Why does it matter? Why is it even something that is worth you spending time thinking about and valuing intentionalism in your estate planning? How to avoid estate plan failure, how to be intentional. So we're going to talk about what it means, why it matters, and then I'm going to try to give you some tips and ideas and pointers on how to be intentional in your estate planning. I'll talk a little bit about the roles that professional advisors play in all of this, and ultimately emphasize the importance of maintenance and updating your estate plan as part of your intentionalism. So what does intentionalism in estate planning actually mean? Never hurts to start with a basic Merriam-Webster definition. So looking to the dictionary, intentional means done by intention or design and having external reference. Synonyms would be conscious, deliberate, intended, knowing, purposeful. So an intentional estate plan means one that is designed and done with your conscious and deliberate and purposeful intention, while also taking into account an external process, which I'll talk more about. But intentionalism in estate planning means having intention, taking the time to think through your purpose in doing an estate plan in the first place. All estate plans are not the same, and this is something that I really want to emphasize and something that I really try to emphasize to every potential client with whom I meet. It is not a package deal where every client ends up with the same estate plan. If that is the case, then they are working with the wrong attorney. Each individual person has their own goals, their own concerns, their own intentions. So each individual's estate plan must be reflective of those individual circumstances and goals and concerns. Each person's estate plan should be intention driven by that particular person. Another thing that I want to emphasize is that intentionalism means really activating your mind in terms of thinking through what estate planning does, what the things are and the factors are that you need to think about, what your own personal circumstances and as I say, goals and concerns are. Intentionalism is something that allows you to avoid the mistakes that can occur when people make assumptions. And that's another thing I want to delve a little bit more into. Frequently, first of all, we all make assumptions. That's a natural part of our brains and our inclinations, is to make assumptions based upon Hollywood, what we've heard from our friends and family members and neighbors. All of these different things lead to us having certain assumptions about everything. And estate planning is no different. So I always try when I meet with clients to identify what assumptions they may be bringing to the table and to try to remove those from their thought process and to try to help them be intentional by really thinking in terms of their specific goals and circumstances, the factors that I'm trying to guide them to think through, and leaving assumptions at the door. Intentionalism does require time. It requires patience. It requires honesty. And of course, I highly recommend the input of appropriate professionals. But this right here, this bullet point, really speaks to why intentionalism in estate planning is something that is often missing. It's easier to not be intentional because intentionalism requires that you take time, that you be patient, that you be honest. And those are all things that can be very difficult and painful. The end point here that I'll make is when someone chooses not to be intentional, that is an intentional choice. So why does intentionalism in your estate planning matter? Why is it something that I emphasize and that I highly recommend that every client really value? My first question is, why even do an estate plan in the first place? And this is always an interesting conversation when I meet with potential clients and I really start talking with them about what is it that's bringing you here? What is it that you are seeking? And often, I would say quite often, it's really this last bullet point. Well, I just know it's something that I'm supposed to do. And a lot of times that comes from, again, my family or my friends or my neighbors. It just seems like this is something that people at a certain age do, or people who have children do, or people who have a certain amount of wealth do, or there's some sort of idea of, well, this is just one of those items on the adult to-do list that I'm supposed to check off. So I'm finally getting around to doing it. So let's just hurry up and get through this so I can check it off. But I really encourage people to put that out of their minds and really take time to think through, what is it that we're doing when we are estate planning? It's not just giving you documents. It's not just there are laws that matter with regard to your estate and what happens. It's not just about taxes. It's not just about wealth. It's not just about any of these things. It's a combination of factors, all of which are personal to the person who's actually doing the planning. And that takes time and patience and the help of an estate planning professional to really think through and work through why you are estate planning in the first place and what it is that you seek to accomplish. So thinking through your goals is the first homework item that I would give you in embarking upon estate planning. Your goals are personal to you, and you are the only one who can identify what those goals are, and you are the only one who can convey those goals to your estate planning attorney. So is a goal of yours to protect yourself against ever having court-ordered guardianship, which is a risk that all adults face if they become incapacitated and don't have the necessary estate planning documents? Well, I'll tell you what, that's a goal that every adult with whom I've spoken has, but they didn't know it because they didn't know it was a risk. That is part of my job, is to introduce them to goals that they didn't even realize that they had because they didn't realize the risks and implications that are involved in estate planning and not having an estate plan. So goal number one typically ends up being a goal. It's just not a goal that you may come to the table knowing that you have. Planning for your long-term care needs. This is another one where frequently people either come see me specifically because this is their concern and they're not aware of or haven't thought through all of the other goals that really should play a part in their estate planning. So people either come to see me because they are worried about long-term care, and typically that's motivated because they're in a crisis situation or a panic situation, or again, they've heard something from TV or neighbors or whatever else. So planning for your long-term care needs is absolutely a significant part of your estate plan. It plays a role, it should play a role, it won't be the only goal that you should have, and it may be a goal that you didn't even know that you had until we really start talking about it. Maybe your goals are planning for your spouse who has dementia, and how will that pan out in terms of government benefits like Medicaid to help pay for your spouse's care. If you die first, is there any particular planning that you can do to protect assets? These are all parts of the conversation, but part of it requires that you think through, is this a goal that I have? Is this part of the reason that I'm coming to see you? Ensuring the care, safety, and well-being of your minor children. This is a big one. Frequently when I meet with younger people, this is their primary reason for coming to see me. It's not necessarily that they fully know all of the impacts of the law in terms of minor children and planning for the risk that parents die while children are still minors. Frequently, they don't know all of the details they need to think through. They just know, I have minor children and I think I'm supposed to have a document in place. So I'm going to talk to an estate planning attorney. So a lot of this is, you may have a primary goal, but part of what I want you to do before you even meet with me or another attorney is to really take the time to think through, are there more goals than just that one? But also speaking with an appropriate professional should help elicit and pull out some of these additional goals. Maybe you want to protect the shares of your ultimate beneficiaries from loss of their inheritance to divorce or the claims of their creditors. Maybe you want to plan appropriately for a loved one who has special needs. You're concerned about their inability to manage money. You're concerned about their eligibility for SSI or Medicaid or other government assistance, and you want to make sure that that doesn't get messed up. Here's a big one. These are ones that always make me laugh when I speak with married couples, because these are either at the forefront of their thinking or it hasn't even occurred to them. So ensuring that your assets never go to your spouse's new spouse. Is that a goal? Well, it may be a goal that you didn't know you had, or it may be the goal that brought you in to see me in the first place. Protecting against the new spousal elective share law. Again, this is part of the role of your estate planning attorney, is advising you on the reality of the law and the impact that it will have on your plan, so that you can add and tell your estate planning attorney whether or not that is a goal that you want to incorporate in your planning. Making sure that estate, gift, income, and inheritance taxes are minimized or eliminated. Again, many times people come to me and say, I want to avoid all of the tax, but not necessarily knowing there are several different types of tax. We have to get granular when we're talking about what are we trying to avoid or minimize? What is it that you should actually be concerned about? And what is it that you should be aware of for the future? And that's a big part of what I'll talk about too, is all that you can do when you do estate planning is be aware of what your goals are in the moment and have further goals added to that list by talking with an estate planning attorney and really having a conversation about goals that you may not know you should have or that you want to have. But that's what you can do in the moment. All that you can do about future changes to the law or future changes to your reality that have an impact on your estate plan is to continue to be intentional by updating and maintaining your plan over time. Maybe your goal is protecting your retirement plan assets for your beneficiaries, or addressing and minimizing the effects of another new law that went into effect at the end of 2019 called the Secure Act. These are all examples of goals. You probably have more than one of these now that I've gone over them, and I would suspect that you probably now have a new goal that you didn't even realize was one of the ones that you should or would have if you were aware of it. So thinking through what your goals are before embarking on estate planning, and then being open to adding to those goals as part of the process. And that's another big piece of it, is that frequently people come in to see me and they have very specific goals in mind, which is great. But it also means that they are sometimes limited in hearing the things that I may go over with them, which are done in an effort to make sure that they have truly identified all of their goals and thought through what it is that they are seeking to accomplish. That's why intentionalism in estate planning matters, because intentionalism is necessary to actually achieve your goals. And that's the entire purpose of estate planning. It's to achieve your specific personal goals. So is it possible to have an unintentional estate plan? The answer is yes, absolutely. And understanding this and the full impact of what is at risk if your estate plan has unintentional, unintended consequences, understanding this is vital to overcoming the obstacles in your path to successful estate planning. So as I said in the beginning, choosing to not be intentional is intentional. So the entire point of estate planning is to make a plan rather than simply leaving things to chance. And making a plan requires being intentional, because otherwise there's really no point to your plan. The reality is that life can be random and unpredictable. My goodness, haven't we had a year that supports that? Life can be random and unpredictable. There are countless unanticipated circumstances. I tell people all the time, I'm not able to predict the future. If you are, you're hired. Until we're able to predict the future, the best that we can do is be intentional in the moment, be conscientious about an unknown future, what risks there are, what planning we can do for those unanticipated risks and contingencies, and the ultimate knowledge that it requires regular maintenance and updating to actually be able to address the random and unpredictable and unanticipated circumstances that life can throw our way. Being intentional in estate planning matters because there is significant interplay between the financial, tax, and estate planning worlds. And I want to take a moment to talk about this a little bit. People often think, I have a will. That covers everything. I don't need to do anything else. I have a will. Everything is covered. That is not true. There are certain types of financial assets that do not go through probate, which means that your will has no bearing on them. And hear me when I say that as well. A will goes through probate. These are all things that I regularly find come as a surprise to people. This is where the financial advisor or the financial planner is so helpful to the estate planning attorney, because by working together, we are able to make sure that whatever your specific intentions are and whatever your specific goals are, that your estate planning documents address those properly, and that all of your financial assets properly correlate and are aligned with your estate planning goals and intentions. So there is significant interplay between your financial reality and what your estate plan is. And tax is wrapped up in all of this. So tax implications, there are always tax implications, always. And so it's always a part of what we need to discuss as part of the estate plan. It doesn't mean that estate tax is a relevant tax to you, but there are many other types of taxes that are a part of the world of estate planning. And so we always have to incorporate that discussion as part of the estate planning discussion. And if you have a tax advisor or a tax preparer or a tax professional, that's a vital person to help play a role in your intentional estate plan. Common knowledge is often incomplete or misunderstood. I think I've already mentioned a number of examples of that. Frequently, there are assumptions that we all make based upon common knowledge or something that is just bantered about as on TV or from Hollywood or amongst social media or whatever else we may hear or learn from. But frequently, that common knowledge is either inapplicable to your specific circumstances, or there's a nuance to it that you may not know. It's simply a reality that assumptions are left at the door. It's best that they are left at the door, and that any sort of common knowledge is not used as the guiding principle in making the decisions, but that a full and thorough discussion is had about your specific goals, your specific assets, and the law and tax, and how all of that has interplay. The reality is that failure in estate planning is quite prevalent. When people skip steps or when they don't have the appropriate advice of appropriate professionals, they can in fact have an estate plan that does not successfully achieve their goals and that may in fact have unintended consequences that are the exact opposite of what they intended or wanted. And so estate planning failure is prevalent, and the best way that we can help clients avoid that is by making sure that intentionalism is a significant part of the estate planning process. But it requires that both sides invest in that, the client and the professionals. So how to be intentional? Here's some guidance on my recommendations for how to approach estate planning in an intentional way. The first step, as I already mentioned, know what you want. What are you seeking to accomplish? What are your personal and specific goals? And I encourage you to really take time to think through that. The easy ones, the ones that are common, I want to make things easier on my family. I want to avoid tax. I don't want my estate to go to the government or to the state. These are common ones that I hear. I want to make sure that my spouse and children are protected. These are all very common goals, and they are good ones, and they are worthwhile ones to bring you in to meet with me or an estate planning attorney. I encourage you to even think beyond that, to get more granular, to really think through what are your goals if you are alive but incapacitated. Put yourself in that situation in your mind. What if you are alive but incapacitated? Who do you want to be able to act on your behalf? And think of some good backup options. And what is it that you want them to be able to do for you? And by this, I'm talking about not only your health care and your physical well-being, but also your finances and your assets and your financial well-being. Who would you want to be in charge or responsible for those things if you're still alive but unable to do all of that for yourself? This is incapacity planning, and this is a significant part of estate planning. Many people don't realize that. It is. So thinking about, if I'm alive but incapacitated, who do I want to be able to act on my behalf? It does not have to be the same person for health and finance. Who do I want to be able to act on my behalf? And what if they're not able to? Then who would I want? And what is it that I want them to be able to do? What is it that I want them to definitely do? And this is especially important in terms of healthcare and physical well-being. I tell clients all the time, you may know in your own mind things that bring you comfort, things that drive you crazy. Your thoughts on end of life situations and palliative care and all of these different things, you know how you feel, but would someone else? And what if there's ever a point in time where you're no longer able to communicate that to them? Think through all of that, and I bet you will add to your goals. And then thinking about after you're gone, and allow yourself to walk through several different scenarios. If you're married and you die first, what if your surviving spouse gets remarried? Just think through that. It doesn't mean that you have to care. It doesn't mean that you have to incorporate anything about that into your estate plan, but I do want you to think about it. Or what if you're gone and the money that you've left for someone, presumably someone that you love, that person becomes disabled or incapacitated, or that person has a divorce, or that person is not a bad person, but they slip on black ice and cause a car accident and get sued. Thinking through these contingencies that are just part of life and how much of that you want to plan for, want to include as goals in your personal estate planning. These are some of the scenarios that I encourage you to think about. I will talk you through other ones that I recommend that you think about based upon your personal family, circumstances, assets, and the goals that you bring to the table as a starting point. So intentionalism in estate planning. Know what you want. What are you seeking? What are you trying to accomplish? Step 2 is selecting the appropriate professional with whom to work to accomplish your intentional estate plan. So selecting the ideal estate planning attorney or estate planning law firm. Now, it won't come as a surprise to you that I'm going to say that I consider myself to be a rather ideal estate planning attorney, and I welcome you to work with me. I also will tell you that I believe that Elville and Associates is an ideal estate planning law firm, and that I welcome that you work with us. But I'll give you support for those arguments. This entire webinar is part of the reason that I say that we are ideal for your estate planning, because intentionalism matters. And too often, estate planning attorneys treat this as a package transaction, as a manufacturing approach, that everyone ends up with the same estate plan. It's one and done. There's no nuance, there's no discussion, there's no really getting into the fine-tuned details to figure out what your intentions are, to help you figure out what your intentions are, and then to take the time to make sure that your estate plan accomplishes and addresses those personal intentions. Many attorneys do not do that, unfortunately, and therefore many clients never realize intentionalism matters, and the estate plan that I have may actually fail because of the lack of intentionalism. Step 3, engage in a partnership type relationship with your estate planning attorney. So this means hearing what I'm saying when we're talking about your particular planning goals. Here are some additional risks or rewards or pros and cons, things that you may not have thought about. I'm asking you to add these to your contemplations. You can say, I don't want to. And as I said, that's intentional. Choosing not to engage in intentionalism is intentional. And that's okay. Obviously, it's not my recommendation, but when I speak with clients and they say, I just don't want to worry about it, or I just don't want to think about it, that is your choice. My job is to guide you on things that you might want to think about, to give you examples and insight into things that you might want to think about that you weren't even aware of. It is a partnership. We have to work together and we both have to invest in that partnership. But part of that also means that you are open to educating yourself through all of the webinars and newsletters and blogs and various things that, at least if you work with me and Elville and Associates, we provide as part of client education, because it is such a vital part of success in your estate plan. But there are many, many, many treatises and other things that you can find to educate yourself on all of these different goals and consequences and concerns and circumstances. My job is to bring them up, to mention them to you, to discuss them with you as much as you'd like, but I always recommend that you also educate yourself, that you participate in the external process of educating yourself thoroughly in order to know for sure which goals matter to you. Step 4, intentionalism in estate planning means being thorough from start to finish. So why do it halfway? Do it all the way. And part of what that means is after you've put together the perfect estate plan for you and your goals and your concerns and your assets, once that's in place, making sure that all of your assets are aligned with your plan. This requires coordinating not only with your estate planning attorney, but if you do have financial and tax advisors, we are a team and our job is to work together to make sure that your estate plan succeeds. Asset alignment is as vital as the estate plan itself. It's part of it. So it's not just having estate planning documents, it's making sure that your assets are aligned with what your estate planning documents say. And then step 5, intentionalism in estate planning means committing to maintaining and updating your estate planning on a systematic basis over the course of the future. This is not a one-time thing. I tell people, view this as a living plan. These are documents that are meant to live with you for the extent of your life and to be ready to go at the moment that they need to be used. And we have no way of predicting the future and no way of predicting when that time will come. So creating the perfect estate plan in year 1 and then having it actually be implemented in year 30, there's no way to guarantee that that's going to succeed because so much has changed over the course of time. And I can give you examples of that even just within the last year and a half. The law changes all the time, all the time. So tax laws change, politicians change, laws change, all of it changes. That's the external reality that your estate plan works within. And the only way that you can make sure that your estate plan is working in conjunction with current law is to keep your plan updated. It also means taking into account changes in your goals and your circumstances and your assets. Most of us would agree over the course of time, all of these things change. My goals now are quite different than my goals were 10 years ago, and are going to be very different 10 years from now. The things that I'm concerned about, the assets that I have, significantly different from 10 years ago and from 10 years from now. So you do have to commit to updating and maintaining your estate plan over time in order to ensure that it will succeed in accomplishing your intentions. As part of this, I recommend that when you do seek out the ideal estate planning attorney, that you seek out one who offers a client care program. That is something that Jeff mentioned in the introduction. We can provide much more information and detail about that, so please reach out if you're interested. But briefly, what a client care program is it's a way that clients are able to actually enroll in the client care program for an annual fee. And in exchange for that, they do not have to remember to reach out to us or remember to take care of various details in keeping their planning up to date and perfected. That job becomes ours. We will make sure every year that your estate plan is up to date, that your asset alignment is up to date, that everything that you've hired us to do continues to be in good shape in case in the next year it's needed. What to avoid?
So Olivia,
Yes,
can I
yes.
have you pause for just a moment? We have one question. I think it's a good question to revisit at this time. So the question is, what does asset alignment really mean?
It's a great question. So I'll give an example. Frequently, I hear, I have a will that covers everything. Well, that's not true necessarily. For example, if you have a 401k or an IRA or a TSP, that type of tax qualified retirement account has something called a beneficiary designation. If you have completed the beneficiary designation on that retirement account, when you die, that is where that asset will go. It will go to your designated beneficiary, regardless of what your will says. Your will has no bearing on that beneficiary designated asset. So asset alignment means when I work with a client and we talk about the macro goals, on a macro level, when you pass away, what do you want to happen to your estate? Where do you want it to go? If someone is thinking of their estate as 100% of their assets, including their 401k, and so they say, well, I would want my estate to go to these people or these charitable organizations or whatever. And they think that when we build, for example, their will, and it says that, they think they're done. Okay, good. That covers everything. But their 401k, when they first started contributing to it 5 years prior, at that point in time, they filled out the beneficiary designation based on whatever their circumstances were 5 years ago. And when we do the estate planning and we talk through their goals and intentions and we build their will, and that's where they want their estate to go, and they don't realize the 401k is not going to go where my will says, it's going to go to the beneficiaries that I designated 5 years ago, which now I've even forgotten. I've forgotten who I designated. So it's the estate planning attorney's job to make sure that clients know that there are different types of assets that are structured and handled in different ways depending upon the estate plan. And so making sure that how your particular assets which are personal to you. Everyone has different types of assets. Some people have similar ones, but people have a variety of different types. So my job as your estate planning attorney is to make sure that I know what are your assets, and so that I can guide you on making sure that however those assets may be structured, it actually aligns with your estate plan. So that's my example. I hope that's helpful. But what asset alignment really means is, I'll give you another example, Jeff. People who have POD on a bank account, and then they come see me and we build their estate plan, and that's current, and that's how they want everything to work. And they don't realize if you leave an account POD, that's where that account goes when you die. It's not going to be a part of what your estate planning document accomplishes. So it's just a matter, asset alignment is just a matter of making sure that your estate plan, which is intended to direct what happens to your estate when you die, in part. An estate plan covers more than that, but one piece is what happens to my stuff when I die. In order to make sure that that's successful and in line with what you're actually intending to accomplish, we have to incorporate the conversation about your assets and how they are structured, and make sure that those are in alignment with your plan. So I hope that helps, and please let me know if you have further questions.
Thank you as always.
So talking a bit about what to avoid. So if you are investing in the idea of intentionalism in estate planning, then part of it is what to avoid. Avoid viewing estate planning as a one-time transaction. As I mentioned previously, it should not be. Everyone who creates an estate plan certainly hopes that they have many, many, many updates in front of them before it's actually necessary. So don't view estate planning as a one-time transaction. It's an ongoing process. And I encourage you to view it as an ongoing process, and you certainly should work with an attorney who encourages you to view it as an ongoing process. Keep it updated. And how often? Well, my recommendation is every 3 to 5 to 7 years. I really wouldn't recommend that you go longer than that. Every 3 to 5 years is a good idea. With the client care program that we offer, you get an annual review to make sure that everything is up to date and perfect. But at the very least, you want to make sure that you do these updates and you revisit your estate plan every 3 to 5 to 7 years at longest. Avoid viewing estate planning as just documents. So asset alignment is part of that. If you think of estate planning as purely the written documents, I signed a will or I signed a trust, so I'm done. No, estate planning requires so much more than that. Not only does it require that what those documents say be specific to you, there should not be the same version of a will or a trust or any other type of estate planning document for every person. There should be nuances based upon you and your specific goals and concerns and family members and beneficiaries and assets. But estate planning also, in addition to having specific, personal, customized documents, it also means having the appropriate asset alignment and input from financial and tax professionals. Avoid a lack of a partnership type relationship. So if it's purely transactional, if it feels like a manufacturing situation, that is what I recommend that you avoid. This is a partnership. The only way we are going to achieve your intentional, successful estate plan is to invest in the partnership together. Avoid having a lack of a defined purpose. So it's okay to come see me without a defined purpose, to have the vague idea that this is just something I should do, so here I am doing it. It's okay for you to show up with that. But what I want you to do is to leave the first meeting having a defined purpose. So being open to defining your purpose over the course of engagement and discussion with me or with your estate planning attorney. I want you to have a defined purpose as you embark upon the estate planning process, even if you didn't have a clearly defined purpose when you first came in to meet with me. Avoid not following up, avoid not maintaining your estate plan. So this has been covered. The idea is it's only going to remain successful if you keep it updated. Avoid a situation where there is no collaboration between the members of your advisory team. If you talk to an estate planning attorney who does not talk about changes in the laws or what the potential future changes may be, or what's being discussed in Washington, D.C. or in Annapolis about things that may or may not end up on the books, if there's no recognition or consideration of changes in the laws such that now you're aware that that's something for you to be aware of and for you to add to your intentionalism, avoid that. If there's no ongoing client education, no offerings of client legal education, I recommend that you avoid that, because the only way that you are going to have a comprehensive understanding of what estate planning accomplishes and what you want yours to accomplish is for there to be sufficient education to help you know that. You absolutely should consider unanticipated contingencies as part of your thought process. So in doing intentional estate planning, part of it is thinking about contingency situations that you're not anticipating, but guess what? None of us can predict the future. So it's important to have those play a part in your thinking, even if what you end up deciding to do is to not worry about those. That's okay, because that's an intentional decision. What I want you to avoid is not making that intentional decision because it doesn't even play a role in your thinking. Avoiding incorrect or non-existent beneficiary designations. This is where the asset alignment comes in, and this is why it's so vital. If you have incorrect or non-existent beneficiary designations on certain types of assets, like life insurance and those tax qualified accounts I mentioned, that can actually ruin your estate plan, and it can lead to failure of your intentions. So improper or incomplete asset alignment, a lack of understanding of the effects of non-probate transfers. Non-probate transfers simply speaks to asset alignment and having assets that are either beneficiary designated or payable on death or transferable on death or jointly owned. These are all examples of non-probate structures, but they can
Olivia,
have, yes.
I'm sorry to interrupt there. I thought you were finished. But to speak to that, there was a specific question about the difference between POD versus TOD, and if one has a choice when completing a beneficiary form. Can you speak to that briefly?
Sure.
Thank you.
Sure. And Jeff, interrupt me at any time, please. So
Thank
POD means payable on death. TOD means transferable on death. They mean the same thing in practice and effect. It's just that different types of financial assets have different, how to even say what I'm trying to say. It's all dictated by the type of asset. So a bank account is something that the bank will make it POD, that you're able to, through your bank, make something POD, payable on death. And that's because it's a bank held asset. There are other types of assets where it's simply titled as TOD, but it accomplishes the same thing. So it's just driven by the type of asset and how that asset titles it, but it accomplishes the same thing, which is that's where that asset will go at the death of the current owner. So that's the difference between the two, is just what the word is, payable versus transferable, but in effect, they're the same. And I'm sorry, Jeff, what was the second part of that question?
The question was, does one have a choice when completing a beneficiary form?
So I'm not completely sure what that means. So if that person can give you a little bit more clarity on what that means, that would be great. So I'll let you interrupt me again. I'm going to keep going. Did you have any other questions right now?
Not right now, thank you.
Okay. All right. So avoiding poor selection of your fiduciaries. And so fiduciaries really means the people that you are naming to handle your financial world on your behalf if you are unable to, and after death to handle your estate and the administration of your estate and the distribution of your estate. So your fiduciaries are sometimes known as your trustee, your personal representative, your executor, your power of attorney. All of these things have fiduciary implications. It's important to select appropriate people for those roles. And you would agree, I'm sure, that it's also important to select an appropriate person to be your agent for healthcare and physical well-being. You want the right person to be in that role. And determining who the right person is takes thinking through what the role entails and certain details that you should think about in considering whom to name. It shouldn't be an automatic knee-jerk, well, of course I'm going to name my son because he's my son. That shouldn't necessarily be the decision maker. And we need to talk through the various elements that I'd like you to think about in making your decision. It may still end up being that your son is the appropriate person, but poor selection of fiduciaries can be brutal to the success of your estate plan in accomplishing your goals. And poor selection of fiduciaries is something that happens when thought doesn't go into the process. So avoid that. Fiduciary legal education. Here's the reality. A lot of clients do name people to be their healthcare agents or their financial agents who may have no idea what that job entails. What does that role mean? What do these legal documents mean? What am I supposed to do? We offer at Elville and Associates, and I always encourage clients to take us up on this, what's called a family meeting or a fiduciary meeting. The purpose of this is, after you've completed your intentional estate plan, let's bring in the people who are actually going to be responsible for implementing it to see if they have any questions or concerns, and to give them at least an introduction to what will be involved when the time comes. It doesn't mean that we have to go into specific details about dollar amounts. It just means giving a general introduction to what the legal documents are and what they mean and how they will play out. And mostly what I always emphasize is the purpose of this fiduciary or family meeting is for you to now know that there is a professional, me, that you can reach out to if and when you are acting under these legal documents. I am here to help guide you at that time. And now you know there's a human behind these documents that you can reach out to for guidance. I also recommend avoiding a lack of organization. I'll give you a very good example. When I'm talking with potential clients and we're working through what are your assets, that's a natural part of what we need to discuss when we're doing an estate plan. I have to have an understanding of what your assets are. That's how I'll be able to talk about tax implications. That's how I'll be able to talk about asset alignment and what that's going to look like. So I do need to understand what your assets are. And that's a process. We work on that together over time. Certainly, if you have a financial advisor, that makes things much easier. But part of the conversation that I have with people is you're having a hard time thinking about everything that you have, which is very natural. What if you became incapacitated or died? The person that you've named to handle your financial picture on your behalf, how are they going to know what you have? How are they going to be able to know what you have that they need to deal with? This is an example of the vital piece organization plays in the success and the intentionalism of your estate plan. So organization means, number one, making sure that you have organized files with regard to assets, finances, and estate planning documents. Number two, that you have an estate planning attorney who's going to try to help keep you organized by having all of that information stored with the estate planning attorney. If you have a financial advisor, that's a tremendous help with regard to having organization in terms of here's another professional who knows information that someone will need if they're acting on my behalf. So organization is a key part of making sure that your intentions succeed. So why knowing what you want in estate planning matters? Being intentional is not easy. And when I meet with people and I give them additional considerations, here are some risks that you probably never thought about. Here are some factors that you probably weren't aware of. And frequently, it does cause discomfort. It does. It is easier to not be intentional. It is easier to kind of skim the surface and check it off the to-do list. I did my estate plan. Now what? Being intentional is not easy, but I encourage that you do it because otherwise there's really not much point to doing your estate plan in the first place. So the roles of advisors. I really recommend that you think of the ideal advisory team as comprised of not only your attorney, but also your financial advisor and tax advisor. This is the ideal advisory team in terms of estate planning, asset protection planning, tax planning. These are all vital pieces in helping you succeed in doing that. And as a Venn diagram shows, there are ways in which each of these professional advisors overlap, and there are ways in which each of these professional advisors have their own distinctive knowledge and experience to bring to the table. So the ideal estate planning attorney encourages you to be intentional, emphasizes that you educate yourself not only while you're planning, but even beyond the scope of that, collaborates with financial and tax advisors, and for clients who don't have those professional advisors, helps them get good ones in place, ensures proper and complete asset alignment, the vital second step of a successful intentional estate plan, offers the necessary services to help you maintain and update your documents and the alignment of your assets, ideally through a client care program, which, as Jeff mentioned, Elville and Associates is the only law firm in Maryland that offers an accredited client care program. Financial and tax advisors, just a few comments from an estate planning attorney's perspective. Some of the reasons that these are such vital professionals, in my opinion, as an estate planning attorney. Frequently, people have a very personal relationship with their financial and tax advisors, and understandably so. And that personal relationship can really help guide the estate planning attorney and guide the estate planning process and bring in pieces and elements that may otherwise be left out that are known to the financial and tax advisor because there's been this ongoing personal relationship. So family history or details about certain children or other family members, all of these things that play a part in the personal relationship that many people have with their financial and tax advisors, that can be very helpful in the estate planning process. Financial and tax advisors are also able to provide objective oversight. And this is something where really what I mean here is, because you typically have an ongoing relationship with your financial and tax advisor, and because they are involved in the investment and the management and the planning of your assets, if there's ever a point in time where someone else is acting on your behalf as your financial power of attorney, as your trustee, whatever the case may be, if they are misstepping, whether intentionally or unintentionally, if mistakes are being made or improper actions are being taken, your financial and tax advisor is going to have some ability to see that that's going on and draw attention to it because they are objectively paying attention to your assets. They can provide significant assistance to the acting fiduciary. One way I mentioned already, your fiduciary steps in to act on your behalf because you're incapacitated. They have no idea what assets you have. Where are your assets? What are your assets? If you have a financial and tax advisor, they can turn to that person for guidance on what your assets are and where they're held. They can provide significant comfort to your family and your beneficiaries in the event that you are incapacitated or do pass away. Having that additional support system of a knowing and helpful advisor who's familiar with you and your assets and your world, that provides a lot of comfort to family and beneficiaries if you're no longer around. And ultimately, they're just very helpful in providing insights to help your estate planning attorney and to help you ensure the success of your estate plan. Sometimes there are too many cooks in the kitchen. That's a common phrase, and that is absolutely true. Sometimes there are too many cooks in the kitchen. But in an estate planning, asset protection, tax planning process, having the clients, the attorney, and financial and tax advisor input, those are the perfect number of cooks. Maintenance and updating and participating in a client care program. A successful estate plan is completely within your control. It pivots on your desire to invest the time and energy necessary to develop a fully functional plan, to be intentional. This is a choice that you make. You don't have to make this choice. I recommend that you do, because otherwise I'm not sure I understand the point of engaging in an estate planning process. So I encourage you to be intentional in order to have a successful estate plan. But you do have to have the desire to invest the necessary time and energy. It does require recognition of the complexities and considerations that you need to be aware of over your lifetime. And that's where that maintenance and updating, because it is not fair to expect you 6 months after you sign your estate plan, but let's be honest, 30 days after you sign your estate plan, it is not fair to expect that you are going to remember and think about details that we talked about in part of the estate planning process. So just come back and see me regularly, and then we can revisit them and talk through them again. And in that period of time, it will be present on your mind for you to make the decisions that are appropriate then versus previously. It's a commitment to a methodical approach. Revisit at least every 2 to 5 years, ideally annually. And Jeff, I think that's the end. So any further questions?
Well, thank you, Olivia. And now is your time. If you have any further questions, to go ahead and pose those to me so I can get them over to Olivia. And I want to thank Olivia again for her time and expertise today in a really interesting topic that's I really enjoyed listening to, because it, to me, gets to the heart of why I come to work every day and why we at Elville and Associates come to work every day. This topic of trying to achieve perfection for your legacy, intentionalism, and estate planning. I think, we encourage you to consider Elville and Associates. As you can hopefully see, by this presentation, we are different than other law firms. We encourage client education. We facilitate planning that works, and we want to be a partner for you and your family members, not just during the initial planning process, but for many years to come. And we encourage you to, if you're not a client, give us a give us a look. If you are a client, thank you for your relationship. And if you haven't come back to see us, now might be a good time. And I thought this was a really good discussion today, led by Olivia. So please give us your questions as I wrap up with a couple of brief items here. We have a number of thank yous to you, Olivia, from some clients here. And we do have a couple of other webinars coming up in the next week. We have on Wednesday, February 10th, Eric Jorgensen, a special needs planner from Special Needs Navigators, putting it all together, a diagnosis to adulthood guide of navigating the disability world. And also Lindsay Moss of our firm, and Allison Stanton, who is an aging life care manager. She is going to be offering a new topic as well, Advanced Healthcare Directives, Busting the Myths. That is Thursday, February 11th at 10:30. And also, so I have as well some follow-up to do for you, and I'll be sending out some general information about our client care program. And I'll also be sending out a link to today's video recording as well, should you want to forward it to anybody or review anything that's really piqued your interest in today's presentation. So let's see if there's any further questions. We had some questions on there, Olivia, and then you answered them.
Excellent.
The person asking the question said that they got their response. So I think we're in good shape. So if there's nothing else, we'd like to thank you for your continued support of our webinar series. Hopefully it's going to be a workshop series again at some point here in the foreseeable future, but I think we're going to still keep the webinar series part because so many people are interested in the webinar aspect of it. So we'll always have the webinar part if and when we get back to being not fully virtual. And so we'll go ahead and call that a successful webinar. So thank you, Olivia. Thanks for being here, everybody. And thanks for your interest in Elville and Associates. Please go ahead and fill out the post-webinar feedback for us. And we look forward to being a resource to you. Have a great day.
Bye.